Mistakes happen, even during criminal trials. However, as the old saying goes, if there was no harm, there's no foul. In Neder v. United States, the United States Supreme Court considered whether this so-called harmless error rule applied when a jury instruction omitted an element of the crime. Ellis Neder was a developer engaged in real estate transactions financed by fraudulently obtained loans. Neder's fraud netted him more than $40 million, which he didn't report on his federal income tax returns. Neder was indicted for mail, wire, and bank fraud and for filing a false income tax return. At trial, the district court judge instructed the jury that, to convict on the bank fraud and tax offenses, it didn't have to consider the materiality of the false statements, reasoning that materiality wasn't a question for the jury. The judge didn't include materiality as an element of the other fraud offenses. Neder objected to both instructions. The jury convicted Neder on all counts. Neder appealed. The 11th Circuit affirmed, finding that the district court erred by failing to submit the question of materiality to the jury for the tax offense. However, the 11th Circuit concluded that the error was harmless because materiality wasn't disputed. It also agreed that materiality wasn't an element of the mail, wire, or bank fraud statutes. The United States Supreme Court granted cert.